appears as though a Republican congressman put in 2 sentences in the Uniform Court of Military Justice in November that would make this law apply to contractors. However, there's been a lot of dispute over whether or not constitutionally that's going to be possible. So even though they've put it in, whether or not this is actually going to work. Moreover, it still relies on a number of problems that I've talked about before. Which kinds of crime is it going to apply to? Are military prosecutors going to be willing to take it on? The other 2 places where we see domestic regulation are in South Africa and the UK. South Africa has a particularly interesting history with private force because one of the major private military companies, Executive Outcomes, was a South African company. And the South African government found Executive Outcomes to be completely embarrassing because they were made up mainly of soldiers who were in this crack battalion, apartheid area battalion, whose job it was to go and fight covert wars in Angola and Mozambique. So the South African government, the new South African government, were not thrilled with the idea that Executive Outcomes was out there. And so they passed the Regulation of Foreign Military Assistance Act in 1998. And it's interesting that they use the term regulation because it was really a ban. It's had all sorts of difficulties, and they've actually tried to revise it very recently. In August, they put it through a new bill, had gone through basically what in Canada we would consider to be its second reading stage, so it still has to go through 1 more reading, of the Prohibition of Mercenary Activities, this incredibly long title. This bill is problematic because it seems to cover South Africans doing just about anything anywhere in the world that you might call an area of armed conflict. And there's been a lot of concern about the fact that it might actually make it impossible for South African NGOs to provide aid in conflict. So it's very likely that it's going to change again. In the United Kingdom, the company Sandline in 1998 was involved in a scandal where it may or may not have been giving arms illegally to the Sierra Leonean government in exile. And as a result of that, the UK commissioned a green paper with the idea that they were going to devise further regulation. That happened in 2001, and nothing has happened since. There are a lot of reasons for why the green paper has been stalled, and the largest of which is one of these classic governmental things. Everyone's arguing about which department of government should do it. So the Home Office doesn't want to do it, the Foreign and Commonwealth Office don't want to do it, and the Ministry of Defense don't want to touch it with a 20-foot pole. So that's actually one of the major reasons why it's been stalled. All forms of domestic system have a number of other rules which could apply. And again, in the American case, we see these most obviously. And that's, you can bring a civil suit. And in the US, you do this through a thing called the Alien Tort Claims Act. And in fact, there are 2 cases pending in the American courts now brought by Iraqis against contractors who were active at Abu Ghraib. It's not a very precise way to go about getting justice, but it's something. And there's some argument that these instruments should be enhanced, so it should be made easier for people to bring civil suits. There are a lot of disadvantages about governing this industry with domestic law, and the first one is it's not an industry which operates domestically, it's an industry which operates internationally. It operates extraterritorially, and it operates in weak states. So as I said before, it operates in states which don't have a lot of judicial capacity themselves. It's very, very, very expensive to legislate from within the US or from within the UK and expect that legislation to control somebody who's operating in Iraq or operating in Afghanistan or operating anywhere else. There are some interesting analogies that you can use with this, and the most interesting one is actually the shipping industry, which is the closest example I can think of an industry which is domestically based, but actually everything it does happens overseas. And the shipping industry is a particularly useful analogy because it also shows us one of the problems. Let's imagine that the UK stops stalling, and everyone agrees that regulations would come through the MOD, and they make it really strict. You're a UK-based company, what's the first thing you're going to do? You're going to locate offshore to somewhere which has easier rules. And this is precisely what we see in the shipping industry. There's a reason why everybody registers in Panama and not in Canada or not in Australia or not in the UK. The other thing that we've already seen this happening is the South African legislation, which I mentioned before. The new legislation has already caused a number of companies to fire their South African employees on the basis that it's too legally complicated to employ them. So one of the difficulties with domestic regulation is if you make it too tight, people will just relocate elsewhere. Finally, one of the problems with all these domestic systems is that private security companies love the idea of regulation. They are the biggest advocates for regulation out there, and the reason why is it makes them look more legitimate. What they want to do is they want to shut down all the little guys, and they want to take over the industry themselves. And they want people not to call them mercenaries and to think of them as very nice contributing members of society, and regulation is the way to do that. But that means that the regulation will be regulation of the willing. What will happen is everybody who wants to be regulated will sign up. And the kinds of people who we should be really, really, really worried about, people like Simon Mann and his friends conducting coups in Equatorial Guinea, the law won't be able to control them at all. And so regulation won't actually do anything to help us deal with the most dangerous manifestations of private force. It will only help us control people who already want to be controlled. International regulation is quite complicated. I'm also going to talk about it more tonight, so I'm going to spend a little bit less time on it now. But again, if you'd like to come tonight or if you have any other questions, I'd be happy to deal with them in the question period. There are 3 documents of international law which deal with mercenaries. Protocol 1, additional to the Geneva Conventions. There's an Organization for African Unity Convention, and then there's a United Nations Convention. The problem with these 3 documents is that they're full of loopholes and they can't be used to deal with mercenaries. Not only that, it's also totally unclear if they apply to private security companies at all because of the way private security companies are organized and because of the fact that private security companies say they don't engage in combat. So basically, this whole body of law that we could spend hours talking about in relation to mercenaries probably doesn't apply to private security companies anyway. The other place that international regulation plays a role is with international humanitarian law. And international humanitarian law can itself be a source of control. And so the International Red Cross has pages and pages about mercenaries and private security companies on their website, and they say that PSCs must abide by the rules of international humanitarian law, just like everybody else. And that's true, except states are really, really bad at following international humanitarian law, and we know who's in charge, and we know how the chain of command works. Private security companies, we don't know any of those things. And so it seems to me that international humanitarian law is a particularly ineffective instrument to deal with this kind of organization. The industry loves international humanitarian law. When you talk to guys who run private security companies, they'll say things to you like, oh, well, we follow international humanitarian law. That's what we want in terms of regulation. To which my answer is, of course that's what you want, because it's very easy. They just say, it's in our code of conduct. We follow international humanitarian law. But again, there's no system of oversight. There's no way to make sure that they're actually doing it. So there are a number of problems with international humanitarian law other than the basic one I've pointed out, which is that states don't really follow it that well either. The International Criminal Court might not have jurisdiction over American contractors or contractors employed by the US because the US has not signed the International Criminal Court, has not signed the Rome Statute. The other thing is that currently no one in Iraq is following the international humanitarian law. If you are a contractor and you get caught in Iraq, there's a big question mark over whether or not you would get prisoner of war status. And the companies get quite worried about this. You know, will our guys get treated as prisoners of war? Well, no one is getting treated as a prisoner of war at the moment if they get caught in Iraq. Neither Iraqis being caught by Americans, nor Americans being caught by Iraqis. So in a sense, this is a bit of a red herring. We could spend a lot of time talking about it, but there is an argument that international humanitarian law, and lawyers get very grumpy with me when I say this, is increasingly out of step with the realities of war anyway, that it was devised to deal with war, and war no longer looks the way that it used to when international humanitarian law was created. And then I referred briefly to this already, but there is a question of status. So are contractors lawful combatants? If you're a lawful combatant, it's a great thing to be. You get prisoner of war status. You get to write letters to your mom from